Hello, good evening, friends. As we have promised you earlier, that we shall be starting a mains cum pre series concerning the most probable topics which can be asked in this year UPSC Prelims 2024. So, I have started with the basic structure of the Constitution. So, in this video concerning the basic structure of the Constitution, I shall be discussing about what is the definition of basic structure, whether any reference has been given about this basic structure in the Constitution, how has it evolved and it has become so much integral part of our Indian polity, and what is the need for the evolution of this basic structure, and what all different case laws were became the basis for its evolution. Then we shall be discussing what are the relevant criticism of this basic structure and what is the outcome that we are deriving from this basic structure of the Constitution. Finally, we shall conclude on a positive note. So, starting the video, we shall be covering the introduction, evolution and criticism, as I have already told you. So, the basic structure, these are the essential features of the Constitution which judiciary, by using their power under Article 137, that is of judicial review, it has over the years it has brought the outcome from several case laws, those were of which government acts were challenged before the Supreme Court. Needless to say, it has not been defined by the Constitution. It is a judicial innovation that was done under Article 137 of the judicial review power of the Supreme Court of India. And to name a few of the basic structures, these include the federal character of the Constitution, unity and integrity of the India, rule of law, among others. These are few of those features which are essential for the existence of India as a nation, as well as the Constitution as a living document, as well as an eternal document. So these are what the essential features of the Constitution. So why are we talking of this basic structure? First of all, needless to say that when our country achieved independence, we have limited resources in terms of financial, but our demands and our aspirations were huge. Our Constitution forefathers have promised us before the Constitution also, who have played a tremendous role in the independence movement, that fundamental right should be an essential feature. Fundamental rights should be granted to every citizen of India. Fundamental rights are those rights which are political in nature. For example, fundamental rights can be divided into four, five, six broad categories, namely right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, among others. And if these rights are violated, then you can directly approach the Supreme Court of India under Article 32, which is it is duty bound to reply if your fundamental rights are being violated, and under Article 226 you can directly approach High Court instead of following the regular method of approaching the lower court and then an appellate court and then High Court. That is not required. If your fundamental rights are being violated, you can directly approach the Supreme Court and High Court under relevant articles of the Constitution of India. Fine, this is that right which is directly provided to the citizen of India under the Constitution of India. However, as I have already said, that these are political rights. Political rights can be enjoyed only if social and economic rights are given to the people. As Dr. Ambedkar has already said that at the base of the political rights lie the social and economic rights, and they together form the trinity. So India at the time of independence, it also suffered from partition, so it had limited resources and it had huge aspirations. Close to 40 crore people, less than 1% were literate. So the constitutional forefathers at that point of time, seeing the situation, they they envisaged for several directives, which becomes a manifesto for the coming generation of governments, such that if such manifestos which are provided in the directive principle of state policy, if these are implemented, the socio-economic condition of the people of this country, they will slowly but steadily they will grow. If such policies and such laws that which are provided in the directives, a huge framework is provided in the directive, if such are implemented, then the social and economic condition of the people will rise, and so will they will easily defend their political rights. So this was a tussle. So at the time of our independence, the then Congress government had a socialistic outlook, because one thing was very sure: the then government, it understood that country came under the grip of colonialism because of one company. So it had the then Nehru government, it was very much clear that we have to control the means of production. This is the basis of socialistic philosophy, the socialistic approach that India follows in its developmental path since independence. So based on the, and also since there was huge inequality present in the society at that point of time, there was at one point of time there were people they were huge landlords, and there were also people who did not have enough money to make their both end meets to make both end meets. So in order to reduce this inequality, the then government, Congress government, it promulgated passed several laws, and such that if those laws, if somehow if they breach the fundamental right, then those people will definitely go for approach the Supreme Court or the Honorable High Court to defend their fundamental right. Then some method or some protection has to be provided to such laws, such that the socialistic objective under which these laws are being made, for example the land reform laws, the tenancy regulation laws, that should remain upheld, so that even if for few section of people the fundamental right is being violated, then if at their cost the welfare of a large number of people, if it is being attained, then that can be that can be based on a social objective, that can be set aside. Fundamental right can be abridged for few people. So this is how the basic structure will start to evolve. Coming forward, let's move forward. So this is the chronology of our basic structure evolution. When the first constitutional amendment was brought by the then Congress government, the first constitutional amendment, it included 130 insertion of one Article 31B, a schedule, that is Schedule 9th, such that close to several number of acts which were kept in the Schedule 9, they were beyond judicial scrutiny. They cannot be challenged in the court of law. It was provided in the Constitution. Fine. That was done using the first Constitutional Amendment Act. So this very act was challenged in the year 1951 directly in the Supreme Court. In this landmark case of Shankari Prasad versus Union of India. So the then High Court judges, they said that Parliament has the power to abridge fundamental rights. Fine. They talked about two different things, that Parliament has both constituent power as well as legislative power. Let me throw some light on the what I am talking right now. Before the Constitution came into existence, there was formation of our Constituent Assembly, which became the basis, which eventually drafted the Constitution of India. That very Constituent Assembly, it was one day sitting as a Constituent Assembly and another day it was sitting as a Legislative Assembly, that is as a Parliament, to pass normal or ordinary laws to run this country. And another day it is sitting as a Constituent Assembly. Constituent Assembly means a body which is elected, nominated, or somehow partially elected, partially nominated in case of India, which has been constituted to frame the constitution of a country. That is a Constituent Assembly, and it has constituent powers. That constituent powers mean that it can recreate a new constitution, or it can destroy an entire constitution, or it can give birth to a new constitution altogether. This is called a constituent power. Fine. So this we will see that, but this is the chronology, how the basic structure of the constitution is evolving. For example, after 1951 Shankari Prasad case, we will see the 17th constitutional amendment was brought by the then Congress government. It was further challenged in Golaknath case. Then the score settled in the favor of Supreme Court in the Golaknath case. Then Congress government further brought a 24th and 25th Constitutional Amendment Act. Then again landmark Keshwanand Bharti case was given, and for that matter, today the Keshwanand Bharti case verdict has completed 51 years. So today the historic day, 24th April 1973, it was then the Keshwanand Bharti verdict came in a split verdict of 7:6, which was settled in the favor of that fundamental right can be abridged, but only for implementing certain directives, as well as the basis of this basic structure was laid in the Keshwanand Bharti case. And then Congress government further brings 39 Constitutional Amendment Act 42nd, and then again in the Minerva Mill case, the Supreme Court further reiterated the judicial review power of the Supreme Court of India. Moving ahead, so coming to the Shankari Prasad case, as I have already told you, so these are the three questions which came before the Honorable Supreme Court at that point of time: whether the first Amendment Act, Constitutional Amendment passed by the Parliament, was unconstitutional. This was the first question, and then whether Parliament has the authority to amend the fundamental rights, and third, whether the word law in Article 13 Clause 2 included constituent laws. So what it is actually talking, if you see Article 13 Clause 2, you will find that none of the ordinary laws, rules, regulations by executive or legislature, it can abridge the fundamental rights of people. It was provided in 13.2. So the question which came before the Shankari Prasad case, whether constitutional amendment is that law, or Constituent Amendment Act does not include a law which is being talked in Article 13 Clause 2, or is it only being talking about an executive action or a legislative ordinary parliamentary act. So in Shankari Prasad case, so Honorable Supreme Court said that Parliament has the power to abridge the fundamental rights. Fine. And it also said that the power, that is the constituent power. Constituent power means you can remove a part of provisions from the Constitution of India, or you can add a new provision in the Constitution of India. This is called a constituent power. This is much more and broader than the normal legislative power. Fine, a normal act. In order to pass a bill, we need just 1/10th quorum in the parliament. For example, if, in order to pass a bill in the Lok Sabha, its total membership is 545. You require just 54-55 odd people. If let's say 60 people are present, and if 31 passes, if say yes in the favor of the bill, then the bill is said to be passed. Fine. But in case of a Amendment Act, if it has to be passed by a special majority, then you require 2/3 majority in order to pass first of all there, and then if it is of such nature that it has to be ratified by half of the state, so that is another case. That means a Constituent Amendment Act is a different it is much more stronger as compared to the Legislative Act. So Supreme Court in this Shankari Prasad case, it said that under Article 13(2) does not mean a Constituent Amendment Act, as well as it's reiterated that Parliament has the authority to amend the fundamental right. That is, if it is implementing a directive under the directive principle of state policy, and if it abridges the fundamental right, so that cannot be challenged. So later, Supreme Court. So later, one further act was passed, the 17th Constitutional Amendment Act, 1964, which further abridges some of the fundamental right of those some people there. So they approached the court in the Golaknath case in 1967. Golaknath case was a state of Punjab in 1967. Supreme Court in this case took a U-turn from its previous judgment of Shankari Prasad case. It said that fundamental rights are sacrosanct and they cannot be amended. Also, fundamental right cannot be amended for the implementation of directive principle of state policy. It said that the Parliament no longer has a constituent powers. Parliament lost those constituent power when the Constituent Assembly was dissolved. Fine. So you cannot amend the fundamental right; they are sacrosanct. Also, it said that means the Constitution Amendment Act, it means laws under Article 13(2). Hence, if it means laws under Article 13(2), so such laws cannot abridge the fundamental rights. Therefore, Parliament doesn't have the constituent power as which were earlier recognized in the Shankari Prasad case, which it had. So we can say that in the Golaknath case 1967, Supreme Court took a U-turn from its previous version or from its previous verdict. So in this way we see that that power to amend the fundamental right, it has been taken out from the Parliament. So Parliament reverted, then Congress government reverted with 124th Constitutional Amendment Act 1971 and reaffirmed its power to abridge any of the fundamental rights. Fine. And then it further came up with the 25th Constitutional Amendment Act of 1971, and by which it inserted Article 31C Clause 1, and Clause 1 says that to implement articles under the DPSP 39B and 39C, if by that implementation Article 1914, that is equality before law and equal protection of law, and the 6 freedoms that are given under Article 19 and Article 31, that is right to property, if it is abridged, then there is no problem. That is what I mean to say. It is given in subsection 2 that if any policy or law is passed to implement the above directives, then the court will not have the power to judicially review these. Fine. Sorry for the disturbance. The court will not have the power to judicially review this. Then the parliament, then the Supreme Court waited, and then it came with the landmark verdict. That is, in the 25th Constitution Amendment Act, Supreme Court has taken the judicial review power of the the Parliament has taken away the judicial review power of the Supreme Court, which is actually provided in the Constitution in Article 137. Then Supreme Court waited, and then it came back with the Keshwanand Bharti case, and on this landmark day, on that landmark day of 24th April 1973, Supreme Court with a razor thin margin of 7:6 split verdict, it declared that Article 31C Section 2 subsection 2 was unconstitutional. It, under the judicial innovation power, it said that judicial review is an essential feature of the Constitution, and it laid down a new model of basic structure doctrine. Basic structure doctrine means what are essential for the functioning of Indian polity, or the existence. What are the main essential features of this Constitution? Without those pillars, this Constitution will not survive at all. This Constitution of India. So those are the essential features. Fine. Though it upheld the 24th Constitutional Amendment Act that Parliament has the power to abridge any of the fundamental rights. That means it took a U-turn again from the perspective of Golaknath case. In Golaknath case, it said that Parliament lost its constituent power on the very day when Constituent Assembly was dissolved, and then again it said that in the Keshwanand Bharti case that it upheld that 24th Constitutional Amendment Act, which said that Parliament has the power to abridge any of the fundamental rights, which means that the Constituent Amendment Act does not mean a law under Article 13(2). Fine. Moving ahead. So again, the court is in the ball. The ball is in the court of the then government. It reverted with 39 Constitutional Amendment Act 1975. It said that Parliament has the. It is said provided in that amendment that the dispute related. Parliament said that dispute related to the election of President, Vice President, Prime Minister, and Speaker, it is beyond the scope of judiciary. Fine. That is in one way or the other, because just before that, in the case of Indira Nehru Gandhi versus Raj Narayan case 1975, the Allahabad High Court, it is set to pronounce a verdict which is in adverse, or which may turn against Indira Gandhi. In the Raj Narayan case, when her, because of some electoral rigging, her candidature for the member of parliament election, which was liable to be cancelled, so she came out with the 39 Constitutional Amendment Act such that the dispute related to the election of President, Vice President, Prime Minister, and Speaker, it is beyond the scope of judiciary. In order to save her Prime Ministership and the Lok Sabha seat, she did this. Finally, in 42nd Constitutional Amendment Act, a provision was provided that made a Constitutional Amendment Act beyond judicial scrutiny. So in one way or the other, it is slowly and steadily taking away the judicial review power of the Supreme Court. The Supreme Court also waited for its turn. Fine. in the Minerva in this landmark case of Minerva Mills versus Union of India 1980, Supreme Court struck down certain portion of the 42nd Constitutional Amendment Act, which took away its power of judicial scrutiny, and reaffirmed what it said in the Keshwanan Bharti case, that judicial review is part of the basic structure of the Constitution, and these powers, these certain essential features, these cannot be taken away from the even by a constitutional amendment act. Further, it said that those acts which have been kept in the Schedule 9th, which was brought by the first constitutional amendment act, only till the date of Keshwanan Bharti case, that is 24th April 1973. Beyond that date, whatever cases are being added in that schedule, those can be judicially reviewed. Before that date, whatever case were added in the schedule 9, those cannot be judicially reviewed. One fact that is slipping from my mind, that this particular thing, whether it was said in Minerva Mills case or IR Coelho case, I have to check this thing and I will later update in the comment section. But in the Minerva Mills, in this landmark case of Minerva Mills and Union of India, Supreme Court struck down certain portion of the 42nd Constitutional Amendment Act, and reaffirmed the judicial review power of the basic structure of the Constitution, is a part of the basic structure of the Constitution. Further, so since then, the basic structure of the Constitution, it is evolving by several case laws. It is growing. For example, these are at present, these are the 20 essential features of the Constitution. Some of them I can read out. That, for example, supremacy of the Constitution, the sovereign democratic republic nature of the Indian polity, secular character of the Constitution, separation of power between legislature, executive and judiciary, federal character of the Constitution. That means even if a constitutional amendment is brought such that if it removes these character, federal character, or for that matter welfare state of the socio-economic justice, judicial review, if the constitutional amendment is trying to remove such characters, such powers from the or such features from the Constitution, then that will be rendered unconstitutional, because these are the essential features of the Constitution. Free and fair election, independence of judiciary, power of High Court under Article 226, 227, power of Supreme Court under Article 32, that is writ petition. 136 means SLP, Article 144, 141, 142. 141 means order passed by Supreme Court is binding on all courts. 142 means doing complete justice. Fine. Moving ahead and reading, what are the criticism of the basic structure doctrine. As a bureaucrat, it is expected from us to have a balanced view. We should not take one-sided view, because what we have seen in this video, that the power has tilted in the favor of judiciary, as the way case laws are being interpreted, the way the cases are dealt in the Supreme Court. Fine. So, as a bureaucrat, it is expected from us that we have to criticize positive criticism and negative criticism. This is what stands bureaucrat apart from ordinary aspirants, future bureaucrats for that matter. So, this is the criticism of the basic structure doctrine, that it is very abstract in nature. It is still evolving. Nothing concrete can be said at any point of time. It is left at the will of the judges. It is totally at the discretion of judges. Critics say, under the guise of basic structure doctrine, judiciary can impose its power even on a democratically elected government. We can see this when the 99th Constitutional Amendment Act was struck down by the then Supreme Court, where the National Judicial Appointment Commission its constitution was declared unconstitutional because it took away the primacy from the Supreme Court, and primacy was given to the executive authority. So when it was struck down, Arun Jaitley, the then finance minister, till the extent I remember, termed this thing as the tyranny of the unelected. That it is reaffirming that even the power of a democratically elected government, it is being nullified by the judges. Fine, this is the criticism. Moving ahead, the outcome. So this is the outcome. Also, this is a prelim specific point, very specific, which is important. It was also asked in one of the years, a single one-liner question, that who is the defender and last interpreter of the Constitution? It is the Supreme Court. By this basic structure doctrine, which is still evolving, we can interpret that at last the ball goes in the court of Supreme Court, and it is the Supreme Court, Honorable Supreme Court, who has to decide whether a government policy or a rule or an act or an executive action, if it abridges the fundamental right, so whether it is constitutional or unconstitutional, it rests on the Supreme Court to decide. Fine. In conclusion, we should say that a balance has to be maintained. Fine. Checks and balances, it has to remain. And all the three pillars of the government, it has to work in tandem, such that governance and justice are delivered to masses. Fine. Thank you everyone. I shall be coming with a new video where we shall discuss the tussle over which all this basic structure doctrine has evolved. That is the tussle between the fundamental right and the directive principle of state policy and their implementation. Thank you, and keep studying.